Hello, and welcome to another episode of Women's Voices in Business. This is a podcast that's presented by the Private Corporate Counsel Program at CPLS-PA. Welcome, and my name is Mary Kogut-Lowell. I'm your host, and I am also the director of the Private Corporate Counsel Program. Now, in this episode of Women's Voices in Business, we're going to discuss a subject that's very important to every business owner, and that is contracts. What is a contract? What do you need to know about typical business contracts? And can contracts be enforced or terminated? And if so, how? So let's go ahead and jump right in. First, contract basics. What is a contract? Well, a contract is an exchange of promises between two or more parties. And why are contracts important? Because miscommunications happen and sometimes people break promises. Let's talk a little bit about oral contracts, because some contracts are in writing and some are oral. Most oral contracts are enforceable in Florida, but the terms of the contract can be very difficult to prove when things go wrong. For that reason, a good business practice is to always have your contracts in writing. Now, certain kinds of contracts have to be in writing, such as contracts for the transfer of real estate. But even if you have a contract that doesn't legally have to be in writing, it's a good practice to have it written to avoid miscommunications. So contracts should create clear outlines or expectations of what is expected from all the parties to the contracts. And if a party does not do what that party promised to do, a written contract will make it easier to enforce the terms of the contract because the terms will be there in writing. So as a business owner, what kinds of contracts are you going to see? Well, anything from contracts with your business partners or associates, customer-client contracts, insurance policies, leases. These are all very common contracts. So let's talk about common business contracts. First, let's talk about property and equipment leases. A lease is a written agreement in which the owner of property allows the use of the property for a specified period of time for specific periodic payments, that's your rent. And then your lease will also specify other terms and conditions. So what's important in a lease, and actually with any kind of a contract, what's really important is that you read and understand the terms of your contract or lease. So if you have a commercial lease for your business, consider, for example, the term of the lease. How long are you obligating yourself? Is it for 2 years, 5 years, 10 years? Who pays for maintenance? And how much does maintenance cost? If you're going to have a build out in your commercial space, who's going to pay for that? What about a renewal term? Are you going to have the right to renew your lease at the termination? Does the lease provide a unilateral right of termination on the part of the landlord? Do you, as a business owner, have the right to assign the lease to another business if you want to change locations? Oh, and what happens in the event of unforeseen circumstances such as a pandemic? And I can tell you, we saw a lot of that over the past few years with COVID. I had a lot of clients who had questions about terminating their lease because of COVID. And another important consideration is whether a personal guarantee is required. So sometimes, even if you have a contract written in the name of your business, sometimes, especially in commercial leases, the lessor may want a personal guarantee from you, the owner. So the bottom line is these are all really important things to understand before you sign your lease. And if you don't understand, you should definitely talk with legal counsel. And as I mentioned, we saw a lot of questions about commercial leases in COVID-19. I had clients come to me who, because of lockdowns, they didn't have their business open and they were unable to make rent payments. So what can happen if I no longer afford to pay the rent due to COVID-19? And I found in most of those cases, the answer would depend on whether the lease had something called a force majeure clause. A force majeure is a larger force or an intervening force. And typically, the lease will say what kind of force will allow the contract to be terminated. And so I know, depending on the contract, it may talk about an act of war, strikes, riots, crimes, act of God. And so one thing to think about if you're going into another commercial lease is, do you want to see if you can put in a termination clause that specific to pandemics? That might help you. So so again, leases I talked about leases for commercial property. We also see a lot of leases for personal property, such as, certain kinds of equipment. It could be a copy machine or whatever. The bottom line is read and understand your lease. That's really, really important. You may also, as a business owner, come across different agreements related to financing. For example, let's say you want to buy a piece of commercial property. You might sign a loan agreement. You're going to sign a promissory note. Read and understand your documents so you know what you're committing yourself to. So those are a couple of very common ones. We also see licensing or franchise agreements. A licensing agreement is a document in which a licensor will grant the right to the licensee to produce, sell, distribute goods, use a name, mark, logo, or use certain technology. And so those are very common. We see them a lot. We have service agreements. Many different businesses have service agreements. You could have a cleaning business, a lawn care business, a pool care business. Many such businesses have service agreements that they use with their clients. And another common agreement that we see is something called a non-disclosure agreement, also referred to as an NDA. And a non-disclosure agreement is a legally enforceable contract between a person or entity that has confidential information and a person or entity that confidential information will be disclosed to. And so if you have proprietary information for your business that you don't want to be out in the public sector, you may need to have a confidentiality agreement. And then sometimes clients will ask, well, what is confidential information? What does that mean? And it's important that what is considered confidential information actually be defined in the non-disclosure agreement. But generally, that would refer to sensitive information that would reasonably be expected to be maintained in a private manner. And when do you need an NDA? The question is, do you have confidential information or business secrets that you wish to protect? So we sometimes see non-disclosure agreements with employees related to confidential information of the business. We also see NDAs with third parties. Let's say that you're wanting to do some sort of a business transaction, but you need to protect your confidential information. So those are very common agreements that we see. And again, before I jump into more, before we talk about how to enforce business contracts, let's talk a little bit more about what are the essential contract terms, because a topic or a theme that I'll return to again and again during today's episode is read and understand your lease, or read and understand your contract. So what should be in your contract? What do you want to see in a written contract? You should see the legal names of the parties. And again, if you're a business owner and have formed some sort of an entity, such as an LLC or a corporation, preferably you're going to want your business contracts to be in the name of the entity, not you personally. Although, as I mentioned previously, sometimes there are contracts where personal guarantee is required. But the correct legal name of the parties should be in there. So make sure the legal names are correct. Contracts should specify the purpose and scope of the agreement, as well as the term. That is, when does the contract begin? When does it end? The contract should specify responsibilities of the parties. and what will be the governing law. Many contracts will see, I work on, for example, will say that this contract will be construed in accordance with the laws of the state of Florida, and we'll also talk about where any lawsuits would be filed. The contract terms should include the payment terms, how the contract will be terminated, and so forth. So again, those are the terms that you should be looking for in your contract. So let's say now you have a contract and you want to know how to enforce your contract, because you may find that the other party to the contract is not complying with that party's obligations under the contract. So how do you enforce that? The first step to do is to, again, look at the terms of your contract, because many contracts will provide how an agreement will be enforced. And that's why many contracts will require the parties to go through alternate dispute resolution before litigation. And by alternate dispute resolution, I'm referring to mediation or arbitration. And actually, litigation can be very, very lengthy and expensive. And so I always encourage people to put something in the contracts to require some sort of alternate dispute resolution, usually mediation, because mediation will give the parties, it'll require them to sit down with a neutral third party and at least try to hash out their differences before a lawsuit is filed. Because, as I said, lawsuits can be very, very lengthy and expensive, and I usually recommend them only as a last resort, because litigation can take years sometimes to go on, and can be draining for a lot of reasons. So definitely consider putting into your contracts a requirement for mediation before litigation. Now, in mediation, as I mentioned, the parties will have a neutral third party whose job it is to help the parties find common ground. And what I really love about mediation is that it keeps control of the dispute with the parties themselves. So in a mediation, you're not forced to sign a settlement agreement or anything, but the mediator will help you find common ground, and then you can resolve the dispute, because once you file a lawsuit, now you've lost control over resolving that litigation. It's going to be in the hands of the court. And if it happens to be an issue that a jury might be called, you'll have a jury deciding. So I like mediation because I like people to keep the control over their own destiny whenever possible. And in a mediation, if you can find common ground, fantastic. And if you can't, though, litigation is the appropriate, and sometimes it's necessary, and it can be, it is an effective tool. I just encourage people to try and resolve disputes before resorting to litigation. And again, a lot of times contracts will talk about the venue, so like where litigation will take place. I mentioned a lot, previously we have a lot of contracts that'll say the contract is governed by Florida law, and any litigation will be in this county or that county, or the state and federal courts in a particular area. So those are commonly found, and they're very useful provisions in a contract. Also, consider in a contract whether you want to have a provision that allows attorney's fees to the prevailing party. That generally is, for many claims, many breach of contract claims, the only way you're going to get a recovery of attorney's fees is if you have an attorney fee provision in your contract. Now, of course, it can be dangerous, because if you're the losing party, you're going to, you'd be required to pay the attorney's fees. But that's something to consider putting into a contract, because the thought of paying the other side's attorney's fees sometimes helps convince people that mediating and getting their dispute resolved is the best way to go. You can also consider something called liquidated damages. A liquidated damage provision in a contract says that in the event that so-and-so breaches the contract, that party will be required to pay X amount of dollars as liquidated damages. Liquidated damages are agreed upon damages, so that in the contract you decide you've agreed that what the amount of the damages will be, and that's something that parties can do. So that's enforcing a contract. When, let's say, the other side hasn't performed that party's duties and you want them to do so, you want to talk about enforcing that contract. But what about if you're in the situation where you want to terminate a contract? And I brought that up previously. We saw that a lot during COVID-19, where we had business owners who were struggling to pay their leases because of government shutdowns caused by COVID. So I had several clients come to me and say, how do I get out of this lease, or how do I get out of this contract? And we come back to the same starting place that I talked about earlier today, is read and understand your contract. That's the first place to start, and definitely consult with legal counsel as needed. Now, if you want to terminate a contract, definitely look at that contract. Does it have a termination clause? Sometimes a contract will provide this party can be terminated by either party with 45 days written notice. Well, if that's what the contract says, and you want to terminate that contract, then you follow the steps set forth in the contract. 45 days written notice to the other party. And there may be another provision in the lease or contract that says any notices have to be sent to be effective. They have to be sent in this manner. It could be email, regular U.S. mail, overnight delivery, whatever you specify in the contract, to this particular address. Let's say you have to mail something. So it's really important to follow the steps exactly as they are in the contract if you want to properly terminate the contract without getting yourself into unnecessary problems. Now, there are a couple of defenses to a breach of contract claim that I'd like to talk about. Let's say you don't have a contract termination clause. Let's just say, for whatever reason, let's say I had a client who was in business with her brother. Her brother became very, very ill and could no longer work. And basically the business started to fall apart, and they had contracts going on. So the question came up, what can we do? Because if you don't fulfill the terms of your contract, then you've breached the contract. And then there may be the possibility of a breach of contract claim, which again, we want to avoid litigation. But what you should be aware of, that there are a couple of defenses. Let's say I stop paying the rent on my lease, and there's a breach of contract claim filed. And it's nobody disputes I didn't pay the rent as it became due. The question is, do I have a defense to that? There are a couple of defenses that I see frequently in that situation. One is called impossibility of performance. That's a defense to a breach of contract claims. If the terms of the contract are impossible to fulfill due to the acts of the other party or an act of nature, you may be released from the contract. Now, it's kind of difficult sometimes to prove impossibility of performance, but that is a possible defense to explore if you're facing the possibility of a breach of contract claim, to see if it may or may not apply to you. Another possible defense is something called frustration of purpose. So if an unforeseen event undermines your primary purpose for entering into the contract, so that performance is radically different from the performance that was contemplated by both parties, and both parties knew of the principal purpose at the time the contract was made, then you may be released from the contract. So again, these are possible defenses. Again, think about the client that I mentioned previously who was in business with her brother. Now her brother was seriously ill. She feels she can't run the business on her own. Now, both of these, we may be able, in the event of a contract claim, we could at least assert the defenses. There's no guarantee that they will that they will prevail with those defenses, but those are possible defenses that may be asserted. And then again, if you want to terminate a contract, if the other party has breached the contract, you may be able to terminate it. And then again, and the final thing is, you can try to negotiate a termination. Let's say you don't have a termination clause that you can exercise. You don't have a valid defense. You just don't want to do the contract anymore. You might be able to approach the other party to the contract and try to negotiate. And that might be something that you can do. But proceed with caution, because if the other party disagrees, the dispute may lead to litigation. So once again, the best practice is to always read and understand that contract before you sign it. If you don't understand it, it's very wise to consult with legal counsel. And if you read it and understand it, and let's say you don't like some of the provisions, it's a good idea to try to negotiate with the other side to see if the other side will change that provision that you don't feel comfortable with. Sometimes they will, sometimes they won't. If they won't, it's your business decision at that point to enter into the contract. But I feel if I was your legal counsel, if you read and understand the contract and you're willing to take that risk, then I've done my job, because I don't want my clients to enter into any contracts if they do not understand all the terms of the contract. So again, today we've talked about the basics of contracts. Contracts are something that you as a business owner, you are going to encounter. You're going to have various different kinds of contracts. We've talked about leases, NDAs, franchise agreements. We talked about what are the essential contract terms, but I keep coming back to the central theme. Please know and understand your contract before you sign it. If something comes up during the course of that contract and you're not sure what to do, refer to those terms. And remember, having that contract in writing can be really helpful down the road. You may think that you have a verbal understanding with somebody, but it turns out when there's a dispute, well, I thought you were going to do this, and the other side says, no, I never said I would do that. You're going to be really grateful when you have that written contract. So as a business matter, it's a good practice to have your contracts in writing. So that is today's discussion on contract basics. Our next episode is going to be about another subject that's very dear to my heart, and that is the subject of intellectual property. And it's also something that's very important to you as a business owner. Intellectual property refers to trademarks, copyrights, and patents. So things like, the name of your business. We're going to be talking about how can you protect different intellectual property in your business. So once again, this is a presentation of the Private Corporate Counsel Program at CPLSPA. Please feel free to reach out to us if you have any questions. Please visit us at our website, privatecorporatecounsel.com. I'm Mary Kogut-Lowell, and I look forward to seeing you the next time. Please continue listening to our podcast to learn more. Contact us at 877-647-7887 or email us at info@privatecorporatecounsel.com to learn more about the Private Corporate Counsel Program and how we can help you and your business on your journey to success.